All right, I think we are back on live now, so we'll continue with the second hearing we have this morning. Actually, we have two different hearings, but we and they're not consolidated cases, but we've agreed in advance to sort of treat them that way, and we're combining this into one hearing. We have, this is from Shawnee County, Kansas District Court. It's number 123-506 and 123-510. And it's entitled, if I'm pronouncing this correctly, I always say SWKI, but from Seward and Stevens County versus Kansas Corporation Commission and Anadarko Natural Gas Company. So let me begin. Who do we have here from the KCC?
Good morning, Your Honor. Brian Fedotin, General Counsel of the Kansas Corporation Commission, here on behalf of the Commission.
And who is here for Anadarko?
Good morning, Judge. James P. Sikora of the firm of Smith, Human and Sikora on behalf of Anadarko Production Company.
Okay,
Anadarko Natural Gas.
I'm getting a lot of background noise from you. I don't know if anyone else is having that issue, but
when counsel, its lips are moving before you hear his words.
I apologize for any issues that I have. I'm doing my best here.
all right, I think it'll work, but let's just go ahead and proceed. And who do we have here for the appellee?
Good morning, Your Honors. Timothy Sear on behalf of the SWKIs. And I would also point out that the sound quality from Judge Malone and Judge Powell at my end is very poor. I can hear Mr. Sikora just fine.
All right, well, I apologize for that. We'll just do our best here and see if we can get this done. We've agreed in advance that we're going to treat KCC and Anadarko basically as joint appellants. Each party is given, or each side is given 30 minutes for your argument this morning. But KCC and Anadarko need to split their time. Counsel, have you decided how you want to do that?
Yes, Your Honor. I think we are going to split the time equally, 15 minutes between the Commission and Anadarko. And then if you also want to hear how we're going to split up time for rebuttal, I can do that now, or if you want, or want me to wait on that.
You can let us know at the beginning of your presentation.
Okay, thank you.
I'm continuing to get a lot of echoing, but we'll do our best with that. I guess we'll proceed with KCC first, and we'll start your 15 minutes, Mr. Fedotin. And how much time do you want for rebuttal?
I'd like to reserve 3 minutes, please.
All right, so that's granted, and go ahead and proceed.
Okay. May it please the court. In 2018, this court remanded this dispute to the Commission to, quote, determine if the contracts were ever filed and approved by the Commission. If not, the Commission is directed to determine in its discretion if the SWKIs are entitled to a remedy for Anadarko's violations, end of quote. The issue on appeal is whether the Commission complied with that second prong. The Commission did fully comply with that second prong of the directive. However, the district court misinterpreted the directive and found that the Commission erred in not determining an appropriate remedy under the filed rate doctrine. The district court committed reversible error in not giving the Commission the full discretion that this court afforded it. In the prior time that this was at the Court of Appeals, this court found, quote, the SWKIs have no basis to complain that they are harmed by paying for the gas they accepted from Anadarko and its related companies over the years simply because of poor record keeping by the Commission or ineffective management at Anadarko resulting in missing filings, end of quote. The commission relied on that language as well as the limited nature of Anadarko's certificate and the fact that these contracts were fully performed for a period of about 15 years to determine that Anadarko hadn't been, I'm sorry, that the SWKIs hadn't been damaged by Anadarko's failure to file the contracts. And therefore the SWKIs were not entitled to a remedy. The district court, it erred in ignoring the contractual language that the commission also relied on about that disputes related to arising from anything related to the contract need to go to arbitration in Houston, Texas. The commission found that the contracts were fully performed. The contracts were valid. The issue of whether they were filed at the commission doesn't go to the validity of the contract. Therefore, you've got to interpret the contract, and Article 13, Section 1 of both gas service agreements, which I've been calling contracts, is unambiguous that, again, any disputes arising out of or relating to this agreement or the breach, termination, or validity thereof, all are supposed to be arbitrated in Houston, Texas. And the case law is that form selection clauses are enforced absent fraud or overreach. Here, there's no allegation of fraud or overreach in those GSAs, and therefore the commission found that this matter should be arbitrated in Houston, Texas, rather than before the commission. The district court erred.
Mr. Coe, may I interrupt you on that point? I quite frankly don't understand the commission's discussion of a contract remedy. This dispute isn't a contract dispute. The sole issue, I thought that was before the commission, was whether the SWKIs were entitled to some sort of remedy for the Anadarko's failure to file the contracts with the commission. That's my understanding of what the sole issue was before the commission, in addition to it having to make a finding as to, in fact, whether those contracts were filed or not. And they did that, but I guess, did the commission understand that that was its duty on remand to do?
What the commission understood was that it was supposed to look at everything anew and see if a remedy was appropriate. But even if you don't think we were right on Texas, we still found that there were no damages to the SWKIs. As we explained, we relied on the language that I read from this court that stated that the SWKIs don't have any basis to complain that they were harmed. And then we looked at the certificates that Anadarko was granted, which basically is a license to do business. They can freely negotiate contracts at any price with anybody. That's what they did. And the contracts were fully performed without complaint for over 15 years. Because of
The other
that,
question I have for you is, and I'm looking at the commission's order from August of 2019, and I
Okay.
take it that's the operative order. I know that there's a subsequent order that the commission issued on after the SWKIs filed, in essence, a motion for reconsideration. But in terms of deciding the issue of whether the SWKIs were entitled to some sort of remedy or not, that's what I understand is the operative order. Am I correct about that?
both the order and the order denying reconsideration were appealed. So they're both the subject orders. And I think the order denying the petition for reconsideration goes into some more detail on the grounds why we found a remedy was inappropriate.
My other question is, did the commission deny a remedy to the SWKIs on the basis that it could not provide relief to the SWKIs, or that it did not view the SWKIs deserving of any remedy?
Sure. Thank you for the opportunity to clarify. No, the commission understood this court's order that it does have the authority to grant relief if relief were warranted. But reviewing the facts and the detailed record, the commission concluded that there was no harm to the SWKIs, and giving them relief would be unjust enrichment to the SWKIs. Again, based on the nature of the contracts, the nature of the certificate, the fact that the contracts were fully performed. So yes, we
So
did.
for any particular paragraph or particular portion of the order that you would direct us to that would support that position you just said?
Yes, Your Honor. I would point you to the order denying petition for reconsideration of order on contract status.
Okay.
And I would look at paragraphs 19 and 20. Paragraph 19 quotes this court talking about the SWKIs do not allege that the rates that they paid were otherwise unreasonable apart from their illegality, i.e. that they weren't filed. It explains the SWKIs chose not to appeal the court's decision, and they can't and shouldn't be able to revisit the court's finding that they did not allege the rates were otherwise unreasonable. And then in paragraph 20, it goes into discussing the limited contract specific certificate that Anadarko has that allows it to furnish natural gas through negotiated contracts, and that there's no requirement that those negotiated contract rates are the same for each customer. So
That's helpful. Thank you very
Sure.
much. The other question I have for you is, trying to think where I've seen this before. It's probably happened. I'm just not recalling it. But this issue, the SWKIs in their motion for reconsideration asked for a hearing. They demanded a hearing.
yes,
And the commission chose to not give them a hearing. I noticed that on appeal, Mr. Fedotin, the KCC doesn't challenge the district court's order that the commission had to give them a hearing. But Anadarko, in its appeal, challenges that order. Why isn't that a waiver? The Anadarko doesn't have the power to grant the SWKIs a hearing. The commission does, and the commission's not challenging that aspect of the district court's order. Explain to me why that's not a waiver of that particular argument.
well, I don't think there's any statutory authority that requires us to hold a hearing.
I know, but you don't challenge it in your brief. In your brief, you're not challenging the district court's order that you grant a hearing.
There was a lot in the district court order, and we explained that they denied us the full discretion that you gave us, and I think that is a pretty wide claim, and that the issue of a hearing fits under the umbrella that the district court presumed a remedy was appropriate and presumed it needed to be some kind of modified filed rate doctrine. So the commission's intent was certainly that any overreach from the district court, including ruling on hearing, would be under that umbrella. I apologize if I wasn't clear in my briefing on that.
Thank you, counsel.
Counsel, let me go back with a question. I want to focus on this paragraph 20 that you referred to in the KCC's order,
Sure.
because I do think this might be the key to everything. In one sentence in paragraph 20, you say, since there is neither an allegation of nor evidence of unreasonable, unfair, unjust, unjustly discriminatory, or unduly preferential rates, the commission has no authority to adjust the rates contained in the GSAs. I'm really focusing on those words, has no authority. You're not reading that as the commission saying that they have no legal authority to grant a remedy. Is that correct?
Correct, Your Honor, and that is the initial order. In response to Judge Powell's question earlier, I was pointing to the order, paragraph 19 and 20 of the order denying reconsideration, which I think does a much better job explaining the commission's rationale.
Right.
But
That's
no,
the order from, that would have been what? A couple months later.
Basically, yes, the parties have 15 days to file a petition for reconsideration, and then we have 30 days to rule on it. So it would be, I don't have the date in front of me, but it would be roughly 45 days.
September 2019.
Yes.
The original order was from August of 19, and then the commission denied the SWKI's motion to reconsider the order in September of 2019.
Yes, I believe that's correct.
Yeah, the order I was just reading from, I believe was the August order. Is that right?
Yeah, yes. So I just want to be clear on that, but
But
no,
if you read that entire sentence, I'm reading it as saying the KCC is saying that there's no evidence in this case to give Anadarko to give the SWKIs any kind of remedy. Would that be correct?
what it's meant to say is there's no evidence that they're entitled to a remedy. If it stated that we don't have authority to do anything, that's probably an unfortunate choice of words. But we under what the Court of Appeals told us, we had full discretion and a legal authority to determine if a remedy was appropriate, and if a remedy was appropriate, to determine how to calculate it. But what we did is we looked at the merits and determined that no remedy was appropriate.
Okay, thank you.
Sure. And
Just to be clear,
again,
Mr. Fidel,
I know I want to save some time for rebuttal.
I'm sorry to interrupt you again.
Sure.
When you make the last point here, just so we're clear on which order we're talking about. You're talking about paragraph 19 and paragraph 20 of the commission's order from September on reconsideration.
Correct.
It supports your view that the commission was saying the SWKIs don't deserve a remedy here because they didn't sustain.
Sure, Your Honor, I believe both orders support that they don't deserve a remedy, but I believe that second order is a better articulation of the. I guess it took me 2 tries to do the trick. So so my apologies on that. But yes, they both support it. But the second one, paragraphs 19 and 20, are a much better explanation. Briefly, just to save some time, I just want to touch on the issue that. I'm sorry, I thought I had heard a question. That we complied fully with the language that this court had in its order. It used discretionary language, and it gave discretion if a remedy was appropriate. That the time value of money, the word may was there. And that was just the discussion of a time value of money is just a tool that the commission could have used in recognition of how punitive the filed rate doctrine is. But the district court and the SWKIs interpret that language to require some form of filed rate doctrine be used, but that ignores the relevant language of may. And so again, it fits into, yes, the commission had authority to do it, but it wasn't required to do so. And the commission reviewed the rather lengthy evidentiary record and found the only real damage was Anadarko didn't comply with the commission rules, and we fined them $50,000, which for the commission standards is a pretty large fine. That we thought was the appropriate remedy because the only party that was harmed was the commission and the commission's authority, not Anadarko, or not the SWKIs, I'm sorry. With that, unless there are any other questions, I would respectfully request that this court reverse the district court's memorandum decision and order and deny the SWKIs petition for judicial review. Thank you.
All right, thank you, counsel. Mr. Zakora, we're now turning over to you. All right, you're on mute right now, counsel. Could you unmute yourself so we can hear you? There you go.
Thank you. With that, Your Honor, I will say that I've appeared before the Court of Appeals many times, but this is the first time by virtual presentation. So please bear with me. I'm not experienced in this, but I'll do my best. When I was thinking of how to craft this argument to present it to be most helpful to the panel in its determination, I tried to key on a number of facts, and I would like to set those out now, facts and discussion of how it fits with the commercial operation of business within our state. The first item that's really important to me is that these are really old contracts. The first contract was entered into on July 1, 1998 between Anadarko and the SWKI Southeast, and the second, June 1, 2002. That's between Anadarko and the SWKI Southwest Central. These contracts, judges, were in effect for 26 years. And they concluded on 2013, and here we are in 2022, talking about those contracts. When I think about this, I think the most instructive and guideposts that the court may look to would be the certificate that was granted to Anadarko by the KCC. And it is particularly instructive to look at the title of it. The title of the certificate is a limited certificate. The contracts were under this statement of applicability. It's applicable to Anadarko service provided in accordance with the limited certificate. And specifically, judges, when you look at the natural gas service that was permitted way back in 2000 by the KCC, it basically is this, and I'm reading quote from the tariff. Natural gas sales service shall be, number one, pursuant to a contract, number two, that contains provisions mutually acceptable to the buyer and Anadarko Gas Company. Three, no service under such contract shall be effective until the contract has been filed with the commission and approved by the commission. Now, let me speak to some items in the record concerning this certificate. The record shows that Anadarko filed 79 contracts on August 3, 2000. The KCC took no action to suspend these filed contracts, and they became effective 30 days later under the provisions of KSA 66-117.
Counsel, let me.
This is where
I did forget to ask you if you wanted to reserve rebuttal time. Do you wish to do that?
Yes, Your Honor, I'd like to please reserve 4 minutes.
All right, that's granted. Go ahead.
Thank you. What is most instructive in this unusual case is what the certificate does not require. The certificate and the tariff operates like a business license. It's the authority to conduct business of natural gas. Number one, there is no requirement to sell to anyone. The only sale purchases are by mutual agreement. Number two, there is no requirement to treat the buyers the same way. Different contracts are expressly provided for in the limited certificate. The natural gas service is exactly what the KCC docket stated. It's limited to the terms of a contract mutually agreed to between Anadarko and the buyer. Now, how did these contracts work from 1992 through and 2002 through 2013? My response is they worked great. The parties operated under the 1998 contract for 15 years without complaint or any incident. The parties operated under the 2000 contract for 11 years without any incident of any type. This is really important to me and hopefully to the panel. Each of these contracts had a 30-day evergreen provision. And in the 26 years, these contracts were re-upped 312 times. They were allowed to continue 312 times over 26 years. This was a contract that these contracts really worked. Then, just to bolster that a bit, if I could, the presidents of both SWKIs each testified under oath that Anadarko fully performed all of its obligations under the contracts. Both agreed that they were openly agreed to the contracts, no duress, freely negotiated and entered into. The president of SWKI Southeast testified that he does not contend Anadarko did not perform at any time during the 15 years. The president of Southwest Central testified that he is not objecting to the contract, that the charges were fair and reasonable, and that he agreed to all of the terms. So what changed? what changed with these contracts that worked so well for 26 years? Well, the KCC, well, let me go back and make one further point, because I think it's an important point. We have two contracts that worked perfectly for 26 years. And what was the result after that? Well, we have two KCC decisions, we have two district court decisions, and we're now at the Court of Appeals for the second time. And there's never been a claim that the contracts were non-performed or anything else even remote to non-performance other than a ministerial filing error, which is contended. And I would note that when you look at this in the final instance, there were 81 contracts that Anadarko filed. 79 were filed in August of 2000. In the commission's remand, they found the 1998 contract and said it was filed also, except that they contended that it was not timely filed. And then the final contract, the 2002 contract, the commission found that we just have no record of it, so we're going to assume it wasn't filed. I would say that Anadarko acted absolutely great in both the contract performance and in the filing of the agreements. Now, what I want to look at now that we've said that, and what I try to do is to harmonize how the law and the contracts and the commission certificate work together for commercial enterprise for the parties who operated in this. There's been nothing out of kilter here whatsoever. And from our view at Anadarko, the commission expressly and precisely followed the mandate of the court. Number one, the court asked it in the mandate, required it in the mandate to hold a hearing, to investigate whether or not the contracts were filed. The commission spends a lot of time doing that. And I want to say to the court, we have 7 volumes of record here. This isn't a case that was decided on no record. We have 7 volumes, okay? So the commission did look, they said, as I indicated, 79 contracts were filed, 1 was filed late, 1 they have no evidence of filing. Then the second mandate of the commission, of the court was, is there a remedy or is there a remedy due in this case? And it was entirely, the Court of Appeals gave the mandate as discretion to the commission to look at the record, to look at the evidence, to look at all the facts and say whether or not there was a remedy. And the remedy was an order. The commission did precisely that. They found there was no remedy, an order. If there was any remedy, we paid $50,000 of a fine for 1 contract that couldn't be filed. There's no evidence of any damage or anything untoward towards the SWKIs at all in this entire 26-year period. So we get to
the civil penalty of $50,000, was that actually paid?
Oh, yes, that was paid years ago, Your Honor.
Okay, all right.
So I do want to make a couple of points before I conclude. Again, trying to harmonize how we operate under the law and how we operate in commerce. I think the Court of Appeals and their mandate was fulfilled. I think what my understanding of what the mandate was that the court wanted to make sure that the KCC did its work in terms of looking at whether or not the contracts were filed. That task was completed down to the end degree. 81 contracts all accounted for. 1 contract they can't find, 80 were filed. Okay. The second thing that the Court of Appeals asked in its mandate was for the commission to consider whether or not there was a remedy due in this circumstance. And I think you can see from my presentation how strongly we would feel that no remedy is appropriate. I don't know what a remedy would be based on in terms of the conduct of Anadarko. Anadarko complied with all of the contract terms. Everyone says that. In fact, in 2013, when the contracts were going to be assigned, the SWKIs appeared at the commission and asked that they not be assigned because the price was going to increase. And that's another point I do want to mention to the commission. In the 26 years of these contracts, judges, the price didn't increase at all. The price was the same for 26 years. It was re-upped 312 monthly time periods. People performed under the contracts. So what we get down to, it seems to me at the end, is how does this court deal with a ministerial filing of one contract out of 81? And why are we back to the court a second time? And the answer to that is we should not be. You know, since 2013, it's been 8 years. And in those 8 years, we've been, as I said, to the commission twice, the Court of Appeals twice, the district court twice. And if you stand back and look at what the SWKIs are really asking for, they're asking for this court to amend a tariff, change a contract that was entered into 24 years ago in the case of the 1998 agreement, and in the case of the 2002 agreement 20 years ago. That's not what courts do, as I understand it, in implementing and applying the law to commercial transactions. The courts don't step back 24 years and redo a contract, especially in this situation. And we respectfully ask that the Court of Appeals to end this proceeding and approve and indicate by order that the commission fulfill the mandate, and that we can continue and not be talking about amending a contract that was entered into 24 years ago. With that, thank you, Your Honor. I appreciate the honor and opportunity to present to the panel.
All right, counsel, thank you very much. Mr. Sear, we're now turning it over to you. If you could, you're mute right now, so if you could get rid of that and give us your presentation. We still can't hear you, Mr. Sear. There you go. You'll have 30. You'll have up to 30 minutes, counsel, for your argument if you wish to have that much time.
All right. Can you hear me now?
Yeah.
All right. Thank you, Your Honors. There are two issues to be decided in this case. The first has been completely ignored and not defended by the commission and by Anadarko at argument, and the KCC failed to even brief the issue in their lead brief. That is that this court lacks jurisdiction to hear this appeal, and the appeal must be dismissed. Now, as much as the SWKIs would like this case to end, you know, we filed the complaint with the commission 8.5 years ago. We have already waited far too long. But the first question that this court must decide, and the other parties have been silent here today, is that there is Kansas appellate case law holding that there is no jurisdiction for the appellate court to hear an appeal of a remand order back to the administrative agency. And that's where we sit here today. They seek to take an appeal to this court of the decision of the district court remanding the case to the commission and ordering them to follow the mandate in SWKI 1. There simply is not any ifs, ands, or buts that this case, that the decision of the district court is not a final judgment or an appealable order, because it does not resolve all issues in the case. That is, the commission has been ordered on remand to take particular action that the district court determined is required of the commission under the mandate of the district court. Now, while I would like nothing better than for this case to move more quickly than it has at this unbelievably slow rate over 8.5 years, there is no exception applicable to this case to give this court jurisdiction. And unfortunately, I believe that if the court would find that there is jurisdiction under some exception, the exception will swallow the rule. That is, that would make all remand orders from a district court back to the administrative agency immediately appealable.
Well, the exception here is that the issue before us is whether or not the commission complied with our mandate from the first case. Now, what better court can resolve that than this court? So that seems to me to be a very narrow exception that would give us jurisdiction to hear this case. And I don't see how that would swallow up all the other cases out there that say that generally when there's a remand, we don't have a final order.
Well, Your Honor, as I said, there is nothing that I would like better than this court to take up the merits of this. But respectfully, I think you'd be stepping into a quagmire as to what are decisions of district courts on remand that are immediately reviewable and what ones are not. But I'm not falling on my sword on that issue because I would prefer to get this case moving.
I think we understand your argument on jurisdiction, and it's a good argument. But why don't you go ahead and proceed to address the merits of the issues before us?
All right, Your Honors. Now, what is it that the commission is required to do? Here we are celebrating, if you will, the exact 4th birthday of Judge Powell's written decision in SWKI 1. 4 years ago, the commission was ordered to take particular action, but the commission, for whatever reason, is not interested in hearing evidence or taking up all of the issues required to be taken up. First of all, Mr. Zakora went on using much of his time to explain why Anadarko thinks the commission got it wrong when the commission found that their contracts with us were not timely filed and approved. That issue isn't before the court. Anadarko did not file a motion for reconsideration before the commission and did not appeal that issue. The contracts were not timely filed and they were not approved by the commission, and Anadarko is not entitled to another bite at the apple. Regardless of how many times Anadarko might have properly filed contracts and got them approved by the commission, they did not in this case, despite the fact that they claimed for years in front of the commission that they had been timely filed and approved. But the fact is, they simply were not. Now they want to argue that the contracts were fair and nobody is entitled to any remedy here. And in fact, Mr. Fedotin, I believe, misstated the record regarding the action of the commission when asked by Judge Powell. The commission, in its orders, found that the commission did not have the power to grant a remedy to the SWKIs. Not that they did not deserve a remedy, but that the commission did not have the power to grant a remedy. As I will explain, that simply cannot be true.
Can you point to where they made that finding that they did not have the power to grant a remedy?
they find in both orders that the filed rate doctrine is an all or nothing rule, and that to grant the time value of money remedy would not be all or nothing, but would be a partial remedy. And the commission found in both orders that they did not have that power. And in fact, they claim that because we say the filed rate doctrine applies, that defeats our claim ab initio, because they say we can't say that we're entitled to a time value of money remedy when our argument is we're entitled to a full refund plus time value of money. So that the commission just has it wrong. They do have the authority to grant a remedy. And in fact, Judge Powell's opinion in SWKI 1 specifically found that under the filed rate doctrine, the time value of money remedy is a recognized remedy, and that was one of the remedies that is available to the commission. That issue's already decided. So what was the commission to do that they did and didn't do on remand? First issue, they had to decide were the contracts filed and approved. The answer to that was unequivocally no. The contracts were not timely filed and were never approved by the commission. Then the commission says we don't have to do anything further because we deemed the contract rates to be reasonable because they were freely negotiated by the parties and performed by the parties. Okay, what does that tell us? First of all, there was no discovery on the reasonableness of the rates. Under the pre-hearing conference order on discovery, the commission said only discovery on the issue of whether the contracts were filed and approved, and refused to allow any discovery on the reasonableness of the rates. Secondly, there was never any hearing on the reasonableness of the rates. They wouldn't even allow the issue to be briefed. They said the only thing to be briefed in the case was the issue of whether the contracts were filed and approved. Now, we know that the commission knows that the commission is to make its own determinations regarding reasonableness. They cite in their order, and I'm reading for it, under KSA 66-1, 205, the commission is empowered to establish rates that are just and reasonable, close quote. The commission has never in this case exercised its power to establish rates that are just and reasonable. And we know from the two times that this court has waded in previously to the filed rate doctrine, that is in the two sunflower cases, that this court has held that whether or not a utility rate was freely negotiated and paid voluntarily is irrelevant to the issue of the commission having to review the rate and approve the rate before it becomes a legal rate. That's where the commission first failed to follow the mandate. Once the commission determined that the rates were unfiled and unapproved, that means there was no legal rate for these contracts. And until the, yes, Your Honor.
I'm sorry to interrupt you, but I thought in reviewing this case again and reviewing my opinion from earlier that the SWKIs abandoned that argument, that they said that their original, when they filed the complaint and when the commission was processing that they retreated from their other claims and based their claims solely on the fact that Anadarko had failed to file the contracts with the commission. And that was their sole basis for relief. They weren't claiming that the rates under the contracts were unreasonable. Am I getting that wrong?
Your Honor, unfortunately, that is wrong. And the reference in SWKI 1 to a pre-hearing conference where your opinion says that the SWKIs failed to raise that claim is without support in the record. There is no point in the record of SWKI 1, or in this case, where SWKIs ever agreed that the rate was reasonable. Now, how do we know that, Your Honor? Well, while Anadarko wants to claim that the rate was reasonable and everybody knew it was reasonable, that's not true. That is, until 2013, the SWKIs had no way to know that Anadarko had failed to file their rates and get them approved. Second of all, the SWKIs had no basis to know that Anadarko was charging a rate to one of its affiliates for the same kind of natural gas, which was less than half the charge that the SWKIs were paying. The commission now knows that. And if there were ever facts that show that rates were prejudicial and discriminatory, and that's two of the standards for the commission to look at when reviewing filed rates, it's clear that the rates were prejudicial and discriminatory and too high. And so from the time that the SWKIs filed their complaint in 2013 to the present, they have always complained that the rates were too high for the same kind of service that Anadarko was providing to others. Now,
Mr. Sear, if that's the case, and what I put in the opinion was wrong, wasn't your client's obligation to come to the court and seek modification or rehearing on that issue? Because that's not a small point here. I mean, because my understanding on a mandate is we were tasking the commission to solely examine the question of whether the SWKIs were entitled to a remedy in light of the Anadarko's failure to file the contract.
Your Honor, first of all, we decided, if you will, with our eyes wide open, not to seek further review on, for example, a petition for review to the Supreme Court, because we believed that we got quite a bit of benefit out of the SWKI 1 decision. But second of all, SWKI 1, to follow the law of Kansas and the filed rate doctrine. And keep in mind, in SWKI 1 did not determine, as both Anadarko and the KCC argue, that SWKI 1 says the filed rate doctrine doesn't apply. That's not true. Instead, SWKI 1 says, under the particular facts of SWKI 1, the court was not going to order a full refund. Okay, now there's a huge difference between not a full refund and no remedy whatsoever. So what is it that the commission was required to do? Well, first of all, Sunflower 1 and 2 tell us that the fact that the rate is negotiated amongst the parties and paid does not mean that the KCC is not to review the rate and determine whether it's reasonable or not. And if it's not reasonable, to determine what a reasonable rate is. So after the KCC found the contracts had not been filed and approved, the KCC should have moved into a determination as to whether the contractual rates were reasonable. If the KCC determined that the rates were unreasonable, for example, because we were paying twice what an Anadarko affiliate was paying, then the KCC should have ordered that there be a refund of the unreasonable portion of the rate. Not a full refund under SWKI 1, but the unreasonable portion of it. Let's suppose, for sake of argument, that would be a 25% or 50% refund. That's the remedy that the filed rate doctrine and Sunflower 1 and Sunflower 2 say must be made by the commission. Okay, now, if you assume that the commission would find that the rate was unreasonable in part, a refund has to be ordered of the difference between the amount paid and the reasonable rate. And then, as the court found in SWKI 1, there should also be a time value of money award, because we know from Sunflower 1 and 2 that until there is what's referred to as an effective date for the rate, that is, a date on which the rate has been approved, the utility is not entitled to payment of that, nor is the customer to have paid it in advance of the effective rate of it. So think of it this way, Your Honors. We started to pay for unfiled, unapproved rate gas 28 years ago. That is 28 years before anybody could have found that the rate was reasonable. Now, Anadarko says, well, that's just unfair to get the time value of money. Well, let me flip it back the other way. Let's suppose that the rate had been approved 28 years ago and the SWKIs had refused to pay it to Anadarko. Would Anadarko say that it's unfair to give them interest when they're paid 28 years late on the gas that they delivered? Of course not. That would be ludicrous. But similarly, the filed rate doctrine and that part of it requiring the time value of money to be repaid compensates the customer, the SWKIs, for the failure of Anadarko to get their rate and their collection of it 28 years prior to them being entitled to recover to be paid the rate. Now, we know that the KCC has refused to take up the issue discovery-wise or hearing-wise relative to any remedy in this case. That's a clear denial of due process. But also, keep in mind the KCC has repeatedly said now that they believe they have no authority to grant any remedy in this case. That simply is not the law, and it's a perversion of the filed rate doctrine. Now, keep in mind also here that this is not a contractual dispute between Anadarko and the SWKIs. This is a complaint procedure. That is, the SWKIs didn't sue Anadarko under the contract. So we're not required to go arbitrate something down in some Texas court. Instead, this is a Kansas statutory complaint proceeding in which the SWKIs filed a complaint with the commission and demanded that the commission take action against Anadarko. Now, obviously, that statutory complaint procedure can't be lateraled off to a state court in Texas. So it's simply wrong for the KCC to claim that there was anything that the SWKIs were to do in the state of Kansas, or that the KCC can wash their hands of this matter and say, oh, you have to go to a Kansas court. Instead, Sunflower 1 and Sunflower 2 say that the commission is charged with broad powers to enforce state law and to enforce its regulations, and that where a rate is unapproved, it's not to be collected by the utility, even if the rate is unreasonably low. Let me repeat that, because that is the true measure and reason for the filed rate doctrine, is utilities know what the law is. Their customers don't. Utilities are to file and get their rates approved by the commission. Customers aren't. And utilities know that they're not entitled to get paid in advance of their rates being approved, even if their rate is unreasonably low compared to the market. Unreasonably low. Now, that's because the filed rate doctrine has been endorsed from all courts from the United States Supreme Court on down. And it's been described by those courts as being draconian, but it's been described by those courts as being necessary to keep utilities from doing exactly what they did here, not following the law and giving preferential rates to certain customers. If the court finds an exception for the filed rate doctrine in this case, parties like Anadarko and the KCC, when they don't like the facts of a case, will drive through that any narrow opening with a Mack truck. And as they've done here, refuse to hear evidence, hear issues, make decisions, grant hearings for 8.5 years simply because they don't like the facts of this case. What happened here in 2013 is the SWKIs learned for the first time that Anadarko did not have legal rates on file with the commission. And we learned for the first time that we were paying more than twice as much for the gas as Anadarko was charging its affiliates for the same type of natural gas. All the commission has to do under the mandate from SWKI 1 is determine, is the rate that was paid reasonable or not? If it's reasonable, then Anadarko keeps the rate, but they got paid 28 years too early. There has to be some remedy awarded to the SWKIs. Otherwise, Anadarko unreasonably benefits from getting paid 28 years in advance. Now, Anadarko and the commission want to say to this court that, well, the commission already fined Anadarko $50,000, so that's done. Well, unfortunately, they've ignored the fact that the order of the commission approving that settlement agreement with Anadarko, where $50,000 was paid, carved out and said the $50,000 does not relate to the claim that the contracts were unfiled and unapproved and that there should be refunds. There's a specific carve out in the settlement order. So the $50,000 that Anadarko paid has nothing to do with a remedy in this case. It was specifically carved out in the commission order. Second of all, even if somebody would think $50,000, would be a fine, it would be wholly inadequate and an abuse of discretion for that to be the remedy in this case. First of all, the $50,000 didn't go to the SWKIs, it went to the commission. It's the SWKIs that started paying 28 years in advance of when they were legally required to pay. Second of all, the SWKIs paid for millions of dollars of natural gas over these years. And any sort of even modest time value of money calculation of millions of dollars paid decades in advance of there being a legally effective date for the rate would show that there would need to be a substantial time value of money refund from Anadarko to the SWKIs. Again, as I pointed out, if Anadarko was claiming that they were getting paid 28 years late, they would certainly claim that they were entitled to a time value of money amount on top of that, such as prejudgment interest or some other interest calculation. So under the mandate of SWKI 1, it is simply wrong and not within the law for the KCC to say we could determine that the contracts were unfiled and unapproved and that's it and go home. Instead, the commission must make its own independent determination as to whether the contract rights are reasonable under Kansas regulatory law, not whether or not they were the contract rate, because Sunflower 2 says that the contract rate is irrelevant to a determination by the commission of whether the rate is reasonable. And Sunflower 2 said that even an unreasonably low rate has to be refunded if the rate was unfiled and unapproved by the commission. So our work is not done in this case, Your Honors, but without a clear ruling from this court as to what it is that the commission is required to do, the commission seems to think that they can make this case go on forever without following the law or the mandate. They've done it for 8.5 years so far, Your Honors. It's time for this case to come to an end after there's a hearing before the commission on whether the rate is reasonable or not, and after the commission determines that there must be a refund at a minimum of at least the time value of money, even if the rate is reasonable. While the court
you're down to about 2 minutes, counsel.
Your Honor, I'll sum up very briefly here. The discretion that the commission may have in this case is not unlimited. Instead, it was an abuse of discretion to determine that no remedy should be made to the SWKIs. And first of all, it's a mistake of law that the commission made a mistake of law when it determined that it could not give them a remedy. It was a mistake of law when there was no hearing before the commission relative to that issue. And anything short of a return of the time value of money to the SWKIs for having paid unapproved and illegal rates starting 28 years in advance is an abuse of any discretion that the commission may have. Thank you for your attention.
All right, thank you, Mr. Sear. We'll now turn back over to the KCC. Mr. Fedotin, I believe you still have your 3 minutes of rebuttal.
Yes, thank you, Your Honor. Real quickly, I want to turn to Judge Powell's earlier question and also point to paragraph 26 and 28 of the order denying a petition for reconsideration. Those further provide the rationale for the commission's decision. Second, I want to touch on jurisdiction very briefly and just point to our reply brief that cites to State v. Dumars, the Ruth Fawcett Trust, and Kansas Baptist Convention, all of which talk about in a second appeal, their determination regarding compliance with the mandate involves questions of law over which this court has unlimited review. So this court has jurisdiction to see if the district court followed the mandate. And then I think it's important that Judge Powell asked about whether the SWKIs abandoned the argument about reliance only on the failure to file. And I understand that the answer that was given was that part of the order was not, or part of the opinion was not supported by the record. It's amply supported by the record. And that's part of the problem we've had with this case that initially this was we had moving targets, but initially it was just there was no filed contract, therefore they get recovery. And that's kind of what they're arguing again today. I think it's interesting and it's important to note that there was a discussion of this was a complaint docket, not a civil suit against Anadarko. And that flows exactly into what we were saying. Because it is a complaint, that's why the $50,000 fine was appropriate. This was the only violation of a commission order was Anadarko's failure to comply with commission orders. That's why they were fined. That's separate and apart from any damages. If the SWKIs really thought they were damaged, they could have proceeded under the contract and gone to arbitration in Texas. They didn't want to do this. They thought this was a quick way to get everything they wanted by saying the contracts were not filed, give us the money. And quickly on the filed rate doctrine, the argument that they paid 28 years in advance, that's just preposterous, because if you take that argument, basically they got the gas 28 years ago. They used the gas 28 years ago. So what Mr. Sear is saying is Anadarko should have given them gas for 28 years and not gotten any payment for 28 years. How is that just? It's not. And lastly, the SWKI said that we are acting like we got unlimited discretion and we abused our discretion. Well, again, reading the Court of Appeals language, it didn't limit our discretion. It said, I apologize, I've got lots of papers in front of me. But it used the word if, and it gave us discretion to determine if a remedy was warranted. And for the reasons best outlined in our order denying the petition for reconsideration, the nature of the certificates, the fact that it's just simply a ministerial error of failing to file, we found that there were no damages. We acted within our discretion. Unless the court has any further questions for me, I will just ask you please to rectify the error of the district court, reverse the district court, and deny their petition for reconsideration. And that would do what Mr. Sear and all of us want to do. It would put an end to this. It would give finality to it. It would say the commission was right. You were not damaged. You're not entitled to any relief, and that would end us. Thank you for your time.
All right, thank you, counsel. Mr. Zakora, you're still entitled to your 4 minutes of rebuttal.
Thank you. I intend to speak from a commercial standpoint, as well as from a legal standpoint, if I could. First of all, if you recall, I tried to go with care and say just what the limited certificate did. The limited certificate provides for filing of contracts. It doesn't say that the contracts all have to be the same. It doesn't say that Mr. Sear's client should get a lower contract. There is none of that there. It's a mutual agreement. What I would say is that the commission did, in fact, have evidence in the record, and I would note for the panel that on page 4 and 5 of our reply brief, it states the record contains multiple copies of documents showing that the SWKIs were charged a rate well within the range of what others were charged. I mean, I think there's 7 or 8 there, and the SWKIs are among the 2 lowest, but that in effect is really irrelevant because the certificate does not provide that they would get any price other than the negotiated price of the contract. The other item, which I'm hearing for the first time, I believe, from Mr. Sear this morning, is that even if the contracts were found to be reasonable, that they believe they're still entitled to the time value of money, which is millions and millions of dollars, even for a reasonable contract, even if there was a specific decision that it was a reasonable price. And let me speak to that point. I think the court knows where I'm heading on this. When you go back and look at a contract that existed from 1998 through 2013. And they're asking that there be a decision on a reasonable, whether or not the price was reasonable on a month-by-month basis for 16 years. That's frankly an impossible task. As I told the commission, what we did was there was no change in the price. If the commission were to, if the court were to order a look at whether or not the price is a reasonable price and reopen that, can Anadarko come back and ask for a higher price? I mean, that's just a place that isn't consistent with the certificate. It isn't consistent with the commercial practice, and it has no place here. The time value of money, as counsel for the commission stated, was simply a marker, as I understood it, if the commission found that a remedy was in order. The commission looked at this. They had 7 volumes of record. They even had a record that said that that SWKI's prices were near the bottom, although they didn't even have to look at that, and that there was no no non-performance, and they found that there was not a remedy. As we indicated in our brief, there's no requirement for a hearing. I'm not sure what a hearing would do after 7 volumes of a contract that was ended 8 years ago. So we believe that this case should end. We believe that the commercial outcome that Mr. Sear argues is just simply unreasonable, and that we believe that at most there was a ministerial misfiling, that the commission looked, there is no remedy due and owing to SWKI's, and that the case should be ended by this court. And I appreciate all of the attention of the judges on this. It's a case that's gone on, and I thank you for your consideration.
All right, counsel, thank you very much for your briefs and your arguments today. As I said earlier, we'll take your case under advisement and get written decisions out to you and your clients just as soon as we possibly can. And with that,